Hi everyone, thank you so much for joining us. I am Julie Kruger and I'm the owner of Kruger Immigration Law. Kruger Immigration Law is a small boutique immigration law firm. We're headquartered in Buffalo, New York, and we have a by appointment only office in Toronto, Ontario, Canada. We handle immigration cases only. We do family immigration, business immigration, citizenship and naturalization cases, removal defense cases, really any kind of immigration case. So if you have an immigration matter that you would like to speak with me about, please give me a call. Our phone number is 716-393-9878. You can find us on the web at www.krugerimmigrationlaw.com, and you can email me at julie@krugerimmigrationlaw.com. So today we are here to talk about yet another new change in policy that makes it unfortunately more difficult for immigrants to legally immigrate to the United States. And this new change takes effect on November 1st, which is this coming Sunday. You've probably already heard a little bit about this change in the news so far, which is the Trump administration's new proclamation about immigrant visa applicants. And this new proclamation kind of builds on the Trump administration's previous travel ban, which excluded people from specific countries to immigrating to the United States. This new ban prevents immigrants who will financially burden the United States healthcare system from entering the United States. So note, this is not a law passed by Congress, or this is not a new regulation issued by a government agency. This new policy was done by presidential proclamation. And it's issued under a section of the immigration law that allows the president to suspend entry to the country any immigrant whose interest would be detrimental to the United States. So, even though it's a proclamation and not a law or regulation, it's designed to be a new ground of inadmissibility to the United States, or inadmissibility are the bars found in the immigration law that bar people from coming into the United States. And whether you're barred under a law or a regulation or something that is only a presidential proclamation, the effect is the same. In the end, it doesn't matter. You're not getting a visa if you're barred under one of those items, and you're separated from your family members or from coming into the United States if you are barred for one of those reasons under this new proclamation. And it's estimated that this new proclamation is going to ban or prevent or reduce immigration to the United States by about 65%. So it's anticipated that many people are going to be denied under this new proclamation. It's already been the subject of lawsuits, including one filed by the American Immigration Lawyers Association, of which I am a member. And it may not even take effect if a judge who's hearing one of these cases decides to put an injunction which would pause the implementation or the effect of the law until the lawsuit's decided. But and because it's a proclamation and not a law decided by Congress, that means a new administration at some point in the future, or this current president could at any moment rescind it, and that law could change. That we've seen that happen before. President Obama had put in DACA, which was a policy only, and new administration under Trump rescinded that policy. And that, really creates chaos when a policy is implemented and then rescinded abruptly. It makes everything very difficult to predict what the laws are going to be in the future, what the policies, and how to properly and legally immigrate to the United States. So this new proclamation bars any immigrant who's going to, quote, financially burden the United States healthcare system, end quote. So that's who's barred from coming into the United States under this new proclamation. And it defines financially burden as the immigrant being covered by approved health insurance within 30 days of the immigrant's entry into the United States, or unless the alien possesses the financial resources to pay for reasonably foreseeable medical costs. I'm going to say that again. And this is very, very new. And so I've got some notes here that I'm reading from. That's why I'm looking down. So I'll say it again. So it's any barring immigrants who will financially burden the United States healthcare system. And financially burden is an immigrant who needs to show that they are being covered by approved health insurance within 30 days of entry into the United States, or unless they can show that they possess the financial resources to pay for reasonably foreseeable medical costs. So here's what is included in approved health insurance. It could be an employer-sponsored plan, could include a retirement plan. It could be an unsubsidized healthcare plan offered just on the individual market in the United States or within a state. Could be a short-term limited duration policy effective for a minimum of 364 days. Could be some kind of catastrophic plan. Could be being covered under a family member's plan. And it could be like a TRICARE plan, a visitor health insurance plan, or a Medicare program, or any other kind of health care plan that provides adequate medical care, coverage for medical care. So note, what I didn't say under these things, two important things to note are do not meet the requirements are Medicaid and Obamacare, the coverage under the Affordable Care Act. Either Medicaid or Obamacare, neither of those will meet the requirements under this new proclamation. So this ban only applies to immigrant visa applicants. This is not for tourists or other non-immigrants. It's immigrant visa applicants. And even within immigrant visa applicants, there are several exceptions. And when you look at those exceptions, you really start to realize that this ban is focused on families. It applies to spouses of U.S. citizens, brothers and sisters of U.S. citizens, and all family members of lawful permanent residents. So most employment-sponsored immigrants are going to be able to show that either their new employer is going to be covering their health care, or that they'll be able to afford their own health care plan. So essentially, this is a family ban. This is a ban on chain migration, and it's a way, without Congress actually deciding to change the laws, to prevent the ability of U.S. citizens and lawful permanent residents to sponsor and bring their family members to the United States. And this is, it's going to be extremely difficult also for diversity visa applicants to show that they meet these requirements. The diversity visa applicants often don't have family members or employment in the United States who may be able to sponsor them or cover them under their health insurance plans. So here are some of the exceptions that are listed in the proclamation. Anyone whose visa was issued before November 3rd. So November 3rd is this coming Sunday. Anybody whose visa is dated before November 3rd, they are not required to show that they meet this new requirement. So if you already have a visa, an immigrant visa in your passport, but you've not yet come to the United States, you are not subject to this new requirement. But if you are anywhere in the process and you do not yet have your visa issued, and your visa is, when it's placed in your passport, is dated November 3rd or later, you are subject to this new requirement. You do have to meet this and show that you either have this medical coverage or can pay for your own foreseeable medical costs. So that's one exception. Other exceptions include parents and children of U.S. citizens. So parents and children. Children are defined as being under the age of 21. And so it's parents and children, no, not spouses. SQ visa applicants are not subject to this new rule. Those are special visas for Iraqi or Afghani, like translators, people who assisted the U.S. government. Returning residents, anyone whose interest would further important United States law enforcement objectives, anyone who's under the age of 18, and anyone whose entry would be in the national interest, and how someone would show that they further important U.S. law enforcement objectives, or how their entry is in the national interest. It just isn't, it's just not in the proclamation. We don't know how someone would meet those requirements. And this also, it does not apply to refugees or asylees. So if you are coming in as a refugee or asylee, this does not apply to you. You don't have to meet this requirement. So the actual rules about how an immigrant is going to prove that they meet this new requirement, these are still being determined and implemented. So how exactly this is going to start taking place on Sunday and Monday when people are being interviewed at the consulate and required to show this, we don't necessarily know right now. So I'm going to tell you what we know so far, and I will update you as I learn more and start to have cases go through this new process. So what we do know is when you have to show this, at least so far, the proclamation says before the visa can be issued. So what that means, does that mean as part of uploading your civil documents package to the National Visa Center? Does that mean you're taking documentation to the consulate or embassy at your interview? We just don't know. Could it be added to the I-130 process? We don't know. It's just sometime before your visa can be issued. Who makes the decision? Ultimately, the consular officer interviewing the applicant. So this is going to be something that is determined at the end of the process by the consular officer. And the language, as we've already kind of hinted a little bit, the language in this proclamation is really vague and broad. Given how fast this was introduced just a couple weeks ago and is taking effect this Sunday, given how fast this is taking effect, I think that there's going to be a really wide variety, at the very least initially, in how this determination is made by individual consular officers at embassies and consulates around the world. Because how much training have they really been given on this new proclamation, on the requirements? How much guidance is out there for them to be able to implement this and make decisions when they have an actual applicant in front of them and are looking at their documentation? So at least initially, I think this is going to be really difficult for the officers to make determinations on, and I think we're going to see decisions all over the place. And the other thing about that is that consular officers' decisions are non-reviewable. That means that when the consular officer makes the decision, there's no appeal from that. If you are denied under this requirement, you're denied. There's no appeal board that you can go to, or higher office or higher level. You can't take this to the Supreme Court. You're denied. So typically when you are at an interview and the consular officer is not satisfied that the applicant meets all the requirements, they will issue a refusal letter, and it will say your immigrant visa is being refused under Section 221G of the Immigration and Nationality Act, or perhaps they will come up with a new refusal worksheet, as they did with the president's prior travel ban, that says you're being denied under this presidential proclamation, or you're being considered for a waiver of it. The proclamation doesn't include a waiver process for this. So as far as we know, there won't be a waiver available for this. So will you have the opportunity to provide more evidence? Typically, if you are denied, you get that 221G refusal letter. The officer will make a brief note about what they're looking for, and you have 1 year to submit additional documentation to show you that you do meet that requirement. So hopefully, at the very least, there would be that opportunity in this situation where if you don't meet those requirements, you'll get that refusal worksheet and have a year to show that you can meet these requirements. So, but if you are not ultimately able to meet that requirement, your visa is going to be denied. You're not going to be able to come to the United States as an immigrant. And if you wanted to try again, you would need to start over at the very beginning of the process with a new I-130. Once an I-130 has been used as part of an immigrant visa process or an adjustment of status process, you can't use that again. So if your visa or adjustment of status application is ultimately denied, you have to start over at the very beginning of the process. Is there a new form to complete? Yes, I think so. There's a proposed new form, which is called the DS 5541. It's the Immigrant Healthcare Questionnaire. And it's still in draft form, and it has been released, but but it's not yet taken actual effect. And so right now it's a really brief questionnaire that basically says, do you meet the requirements, and asks you a couple questions about it. Prove how, what date does your coverage start? So we'll see if that's, the initial form, if that is approved, or if additional questions are added to that at some point. What has the Department of State said so far in terms of instructions? Very little. Officers are going to review the medical and financial documentation that's already part of the applicant's case file, and they may request additional documentation or information as needed. They've also said that prior to the visa interview, applicants may wish to review costs and eligibility requirements for approved health insurance plans, or consider how they would pay for reasonably foreseeable medical costs of any current medical condition they may have. So that's really important to note because that means that if you have a medical condition, it appears that is going to be taken into consideration as part of your visa process, and whether or not you're going to be issued an immigrant visa. So in the past, the medical exam that immigrant applicants are required to undergo has been focused on communicable diseases of public health significance. So diseases that you're, an immigrant coming into the United States, that, if that were something that were able to be spread, would be obviously bad for other people to get. So communicable diseases of public health significance. However, this seems to expand that dramatically. And anyone who has a medical condition that potentially has medical costs associated with it, that will be taken into consideration. What is that medical condition? What are the costs associated with treating that? And is the applicant able to pay for those costs or afford health insurance that could pay for those costs? So that's really a dramatic expansion of the medical evidence that's looked at and considered as part of a visa applicant's immigrant visa application. So that's about what we know right now. So this, again, is going to start on Sunday, and we are going to start to see how this is being implemented at consulates and embassies around the world. So if you are in the immigrant visa process, anywhere in the process, and your visa has not already been issued, this is going to apply to your case unless you meet one of those exceptions that we talked about. So really, especially if you are a spouse of a U.S. citizen, if you are a family member of a lawful permanent resident, or if you are a diversity visa application, this is really going to apply, heavily focused on you, and you should really start to be thinking about this immediately and how you're going to meet this requirement. So if you are subject to this requirement and you would like to speak with me about it, about how this is going to apply to your case, about whether or not you're going to be able to meet it, please reach out to my office. You can find us on the web at www.krugerimmigrationlaw.com. You can give me a call at 716-393-9878, and you can email me at julie@krugerimmigrationlaw.com. Julie is Julie, Kruger is Kruger. I'd be happy to speak with you about this. We do offer a free case evaluation for family-based cases, so we can, talk with you about your immigrant visa process and whether or not, you're going to be able to meet this requirements, and what you should do to show that you can meet the requirement, and what you're going to be able to do if you can't meet the requirement. So that's as much as we know so far about the new presidential proclamation, the new essentially family ban or chain migration ban that the Trump administration has put into place, suspending entry of any immigrant who will be a burden on the U.S. healthcare system. Thank you so much for joining us today, and please join us next time. Have a great day.